subscribe, and don't forget to hit the bell icon. And for any query, call me in 7002926537 for any question and legal query. So let's begin the Employee Compensation Act 1923. So let's start. So Employees Compensation Act, what are the remedies open? So the first question, what are the defense available to employers, and under what circumstances can an employer deny compensation to an employee? Section 3 of the Employees Compensation Act provides that for the employer's liability for compensation. According to Section 3, Clause 1, liability of the employer to pay compensation is dependent on the following four conditions. Injury must be personal. Injury must be by an accident. Injury must be personal and injury by the accident. There must be a personal injury and injury must be by an accident. Accident have arisen out of or in course of employment. If the injury has arisen in course of employment, then the question of compensation comes. So injury must have resulted either in injury must be personal, injury must be by accident and arisen out or in course of employment. An injury must have resulted either in death or total or a partial disablement for a period exceeding 3 days. That means total disablement or partial disablement which exceeds 3 days. Okay. Then the question of compensation comes. Number 2, if an employee employed in any employment specified in Part 1 of the Schedule 3 contracts any disease specified therein as an occupational disease peculiar to that employment, or if an employee in the service of an employer in whose service he has been employed for a continuous period of not less than 6 months, which period shall not include a period of service under any other employer in the same kind of employment. In any employment specified in Part B of the Schedule 2, contracts any disease specified therein as an occupational disease peculiar to that employment, or if an employee, while in the service of one or more employers in any employment specified in Part C of Schedule 3, for such continuous period as the central government may specify in respect of such employment, contracts any disease specified therein as an occupational disease peculiar to that employment, the contracting of the disease shall be deemed to be an injury by accident within the meaning of this section, and unless the contrary is proved, accident shall be deemed to have arisen out and in the course of the employment. So if what is the condition? If an employee employed in any employment specified in Part A of Schedule 3, that means employment must be specified in which part? Part A of Schedule 3, contracts any disease specified therein as an occupational disease peculiar to that employment. That means in that particular Schedule 3 or Part A of Schedule 3, part of Schedule 3, there must be disease must be specified as occupational disease which is peculiar to that employment, and an employee while in the service of the employer in whose service he has been employed for a continuous period of not less than 6 months. There must be a service of minimum 6 months. That means, hello, good morning. Service must be continuous for 6 months minimum, not less than that, which period shall not include a period of service under any other employer in the same kind of employment in any employment specified in Part B of Schedule 2. Contracts any disease specified therein as an occupational disease peculiar to that employment, or if an employee while in the service of one or more employers in any employment specified in Part C of Schedule 3 for such continuous period as the central government may specify in respect of each such employment, contracts any disease specified therein as an occupational disease peculiar to that employment, the contracting of the disease shall be deemed to be an injury by accident within the meaning of this section, and unless the contrary is proved, the accident shall be deemed to have arisen out and in the course of the employment, provided that if it is proved that an employee, while in the service of one or more employers in any employment specified in Part C of Schedule 3, has contracted any disease specified therein as an occupational disease peculiar to that employment during a continuous period which is less than the period specified under this subsection for that employment, and that the diseases arisen out or in course of the employment, the contracting of such disease shall be deemed to be an injury by accident within the meaning of this section. Provided further that if it is proved that an employee who having served under any employer in any employment specified in Part B of Schedule 3, or who having served under one or more employers in any employment specified in Part C of that schedule for continuous period specified under this subsection for that employment, and he has after the cessation of such service contracted any disease specified in the Part B or the said Part C, as the case may be, as an occupational disease peculiar to that employment, and such disease arose out of the employment, the contracting of the disease shall be deemed to be an injury by accident within the meaning of this section. It makes very clear that the employee who contracts occupational disease after he has left his employment may get compensation if the above conditions are satisfied. If an employee employed in any employment specified in Part C of Schedule 3 contracts any occupational disease peculiar to that employment, the contracting whereof is deemed to be an injury by accident within the meaning of this section, and such employment was under more than one employer, all the employers shall be liable for payment of the compensation in such proportion as the Commissioner may in the circumstances deem fit. So the third point, what is the second point? 2A states that if the employee employed in any employment specified in which part? Part C of Schedule 3 contracts any occupational disease which is peculiar to that employment, the contracting whereof is deemed to be an injury by accident within the meaning of this section, and such employment was under more than one employer, all such employers shall be liable. How they will liable? In proportion, in such proportion. Liable for what? Liable for compensation. In which proportion? In what proportion? As the Commissioner may in circumstances deem fit. The central government. 3. The central government in case of employment specified in Part A and B of Schedule 3. Which part? Part A and B of Schedule 3. Who? Central government. In which case employment specified in Part A and B of Schedule 3. The central government in case of employments specified in Part C or that schedule, after giving by notification in the official gazette, where they will provide notification in official gazette. Central government in case of employment specified in Part C of that schedule, after giving notification in the official gazette not less than 3 months, that minimum 3 months notice of its intention to do so, may by like notification add any description of employment to the employment specified in Schedule 3, and shall specify in case of employment so added that diseases which should be deemed for the purpose of this section to be occupational diseases peculiar to that employment respectively, and thereupon the provision of subsection 2 shall apply, as if such diseases have been declared by this act to be occupational diseases peculiar to that employment. So what state government will do? It will declare by official gazette for not less than 3 months its notice 3 months notice of its intention to do. What it will do? It declare any disease as the occupational disease peculiar to that employment. Shall specify in case of employment so that the disease which shall be deemed for the purpose of this section to be occupational disease peculiar to that employment respectively, and thereupon the provision of subsection 2 shall apply, as if such disease has been declared by this act to be occupational disease peculiar to that employment. Service provided by so 4 service provided by subsection 2 2a and 3. No compensation shall be payable to an employee in respect of any disease unless the disease is directly attributable to a specified injury by accident arising out or in course of employment. That means no compensation shall be payable to an employee in respect of any disease unless this disease is directly attributable to a specified injury by accident arising out of or in course of employment. 5. Nothing herein contained shall be deemed to confer any right to compensation on an employee in respect of any injury if he has instituted a civil court a suit for damages in respect of injury against the employer or any other person, and no suit for damages shall be maintainable by the employee in any court of law in respect of any injury. So if the suit has been filed by any employee and that suit is not maintainable, then no compensation shall be paid. Nothing herein contained shall be deemed to confer any right to compensation on an employee in respect of an injury if he has instituted in a civil court a suit for damages in respect of an injury against an employer or any other person, and no suit for damages shall be maintainable by an employee in any court of law in respect of an injury if he has instituted a claim for compensation in respect of an injury before a commissioner, or if an agreement has come between the employee and his employer, providing for the payment of compensation in respect of an injury in accordance with the provisions of this Act. So, authorities to determine compensation. Who are the authorities who will determine the compensation? The Act provides that any question regarding payment of compensation, etc., shall, in the default of an agreement, it provides that any question regarding payment of compensation, etc., shall, in default of an agreement, be decided by the Commissioner. The Commissioner is appointed by state government by notification in the official gazette. A Commissioner shall be deemed to be a public servant within the meaning of Indian Penal Code 1860. Now, BNSS and BNS, BSA. Thus, any person required to produce any document or thing or to give any information by Commissioner shall be deemed to be legally bound to do so within the meaning of Section 175 and 176 of the IPC Code. Qualification is prescribed for appointment of Commissioner. Amendment made in 2009 in Section 20 provides that government may appoint any person who is a member of a state judicial service or has been a member of state judicial service for a period not less than 5 years. The minimum 5 years state judicial service member must be appointed as an advocate. 5-year advocate or pleader or have been gazetted officer for not less than 5 years, having education, qualification, and experience in personal management, human resource development, and distribution. So, who is the Commissioner? The Act provides for any question regarding payment or compensation shall, in default of an agreement, be decided by Commissioner. Commissioner is appointed by state government by notification in the official gazette. Commissioner shall be deemed to be a public servant within the meaning of IPC. Thus, any person required to produce any document, thing, or to give any information by Commissioner shall be deemed to be legally bound to do so within the meaning of 175, 176 IPC. Qualifications is prescribed for appointment of Commissioner. Amendment made in 2009 in Section 20 provides that the government may appoint any person who is or has been a member of state judicial service for a period not less than 5 years or is not less than 5 years an advocate or has been for not less than 5 years an advocate or a pleader or is a gazetted officer for not less than 5 years or has been a gazetted officer for not less than 5 years, having education qualification and experience in personal management, human resource development, and industrial relations. So these are the qualifications for being appointed as commissioner, who will determine the compensation. In Rukhsana versus Nafurunisha, the Supreme Court has held in clear terms that for the disbursement of the compensation in case of death of the employee in course of duty, succession certificate is not required. The court need only decide who is the legal representative and the share each is entitled to on the basis of the applicable law. It may be noted that the compensation shall be available only when the condition of Section 3 are fulfilled. Defense available to employer. An employer may take any one of the following defenses or more of the following defenses against a claim for compensation by employee, namely. So what is the defenses? What are the defenses? So who will take the defenses? Employer may take defenses. So what are the defenses? That the accident did not arise out of the employment of the worker. Accident did not arise out of the employment of the worker or in the course of the employment of the worker. That the injury caused by the accident did not result in any kind of partial or total disablement of the employee. That the accident was due to influence of intoxicants or drugs. Disobedience of instruction for safety. He did not he disobeyed the instruction for safety. Instructions must be in a language which the employee can understand, and safety instrument must be easily available. Aryan Muni versus Union of India, 1974 case. Willful removal or disregard of a safety guard or other device for avoiding the accident. So these are the defenses which are available for the in the disposal of the employer. Thank you so much for watching this video.